In this damn near 30-minute video, we're going to explain how the hell Drew Finland just pulled off a major victory, because no matter what happens, the government is going to have to respond the way in which Drew wants them to, which is a big old W. Let's get into specificity right now. And let's get to what this is all about. Defendant Durk Banks' response to government second supplement regarding his motion for a bill of particulars. The Supreme Court has warned that a vague indictment leaves the prosecution free to roam at large to shift its theory of criminality so as to take advantage of each passing vicissitudes of the trial and appeal. Then they use Russell versus United States and United States versus Nance. With a vague indictment, the United States attorney would have a free hand to insert the vital part of the indictment without reference to the grand jury. The law does not vest him with such authority. This sounds like some old ass people talking, don't it? Anyways, the prosecution is indeed roaming at large. And at the very least, a bill of particulars is necessary to put that roaming to an end. The clearest example of the prosecutor's free hand, and one that we see unfolding in real time, is with respect to the nature of the quid pro quo that allegedly motivated the murder. Not one government witness has ever said that Mr. Banks paid for or offered to pay for the charged murder with music videos or rap lyrics. Not one government witness has ever said that his motive to commit murder was to be featured in a music video or rap songs. Bro, they being petty as hell. United States versus Charm, reversing conviction where there was no evidence that cash paid by solicitor to murderer, was the motive for the murder. Yet, these prosecutors have decided on their own, and in the absence of corroboration, that any musical collaboration between Mr. Banks and any alleged co-conspirators post dating August 19, 2022 was quid pro quo for murder. The timing of this development exacerbates its prejudicial effect. Either the prosecutors just invented the theory 2.5 weeks ago, or they have purposely hidden this theory from the defense until then. Either way, it is not fair and cannot stand. If the court does not dismiss the indictment as vague, it should at least take firm measures to guard against the constant shifting of the government's quid pro quo theory. The government should order a bill of particulars and review the grand jury transcripts in camera to ensure that the theory presented at trial is tied to what was presented to the grand jury. At the very least, the court should contain the government's theory to what is contained in discovery it relied upon in response to the court's November 18th order. See docket number 293, 6 exhibits filed under seal. The filing contained no evidence that the music videos and rap lyrics upon which the government now relies were consideration for the murder, and for good reason. No such evidence exists. In lieu of evidence, we have the very thing that higher courts have repeatedly cautioned against: prosecutors who fill in the gaps in order to win convictions. Murderman hands, bang! Before we move on, here's something you can do and get paid for. This is called free cash. Free cash is number 2 on the Apple Store and pays you to play games. You can make $500 plus a month by playing games for free. Use my QR code or the link in the description to get $5 when you download and sign up for free. Download and get paid on your phone and start playing. Y'all still think he's staying in the pen forever? Remember, we had one superseding indictment. They scrapped that and created a second superseding indictment. That's like me saying, hey, bro, I'm finna sue you for saying that I'm ugly as hell. And then shift and say, nah, I'm suing you for saying I'm fat as hell. Which one is it? They're basically saying, no. The shit that you said, this is the reason for why we got these charges right here. The shit you saying, you got to stick to that. Why are you shifting the argument now to say, oh, because you couldn't find the money? Oh, the feds, y'all can't find the damn money that y'all witness said. See, the feds are slowly realizing that the quote unquote snitches that they have are lying. So they're now shifting, saying, well, y'all was about to be backup dancers, and that's why y'all killed Lil Pop to be backup dancers. Nigga, what? Come on now. Let's get into this bullshit. This is why I don't run with the popular theory, the popular crowd, because they're not like us. No shot at Kendrick Lamar, shout out or nothing like that. But they're not like us. Everybody who's watching this video knows one or two things. We're going to break down the paperwork specifically, and we're going to break down what the coded language actually is. That's why they said it's so complex in coded language and all this bullshit. You mean to tell me now it's so hard pressed for this shit? Now the feds, they're going to fire back, and they're going to have to talk. Like, it's going to get dirty. But anyways, let's continue on. Roll it. The dangers of a vague indictment realized. That's crazy. That's a hell of a way to start that off. My bad, y'all. A real danger created by this indictment's vagueness is that at trial, the government could point to any instance of Mr. Banks' generosity with an alleged co-conspirator, or at any time an alleged co-conspirator receives a benefit from his proximity to Mr. Banks' success. The government will cite it as bounty or downstream benefit of the murder. If Mr. Banks picks up a dinner tab, if Mr. Banks buys somebody a gift, if Mr. Banks allows somebody to accompany him on a private flight, if someone collaborates with him on a musical project, the government may decide that this is the murder quid pro quo. This is problematic for several reasons. One reason is that a pecuniary benefit paid by the solicitor of a murder to the murderer does not satisfy the statute's quid pro quo requirement in the absence of any overt agreement or understanding between the solicitor and the murderer that the pecuniary benefit is in exchange for the murder. Instead, for some other purpose. Chong, we ain't finna do all that. In Chong, the Ninth Circuit reversed the defendant's conviction because the evidence did not support the government's claim that this money was promised to the murderer in exchange for murdering the victim. Holding that a promise of a favor does not satisfy the statute in the absence of an understanding as to the form it would actually take. United States versus Phillips. Holding that a legally unenforceable promise to forgive a loan satisfies the statute as long as there is a clear mutual agreement between the solicitor and the hitman of payment in exchange for murder, absent any evidence that Mr. Banks' purpose in bestowing benefits on others is to induce a murder, then those benefits are irrelevant. Another class of problems is that described by the seminal long line of cases on the dangers of a vague indictment without clarity. What did Mr. Banks allegedly pay or promise to pay as quid pro quo for the murder? Mr. Banks is not permitted the opportunity to prepare an adequate defense or to address himself to the relevant questions of fact and law. The government's theory at trial strays from what was presented to the grand jury. The vagueness permits the government to shift its legal theory as the case progresses, as the government has been doing here. And it creates the risk that a defendant will be deprived of the protection against double jeopardy. In this prosecution, we will see these dangers unfolding as outlined below. Government's quid pro quo theory continues to shift. In the last several weeks, the government's theory of guilt with respect to the murder quid pro quo, what it colloquially calls the bounty, has taken a turn. The government for the first time articulates the theory that certain listed music video and rap song features are the bargain for consideration for the charged murder. In other words, the opportunity to rap a verse or appear in certain music video is now, for the first time, alleged to be the payment for exchange for the murder. It'd be the payment exchange for the murder, pardon me. The first two 404B notices contain no allegation of any rap lyrics or videos or consideration for murder. The government's first 404B notice contains no allegation that any lyrics or videos were payment in exchange for the charged murder. The notice dated September 15, 2025 lists 4 songs. Its proffered purpose for admitting one of the songs is that it is an admission that Mr. Banks was under pressure to avenge King Von's death. As to the other 3 songs, the government proffered that they are admissions by Mr. Banks that he ordered violence and paid bounties. Similarly, the government's second 404B notice does not advance the theory that Mr. Banks paid for this murder with rap song and music video features. The notice dated November 17, 2025 adds 2 songs by Mr. Banks to its previous list, allegedly by admissions by Mr. Banks that he pays for bounties and directs violence, reasons contained in the first notice, and also for the new purpose of showing Mr. Banks' relationship with his OTF co-conspirators. The second notice lists 4 new songs as proposed 404B against Mr. Wilson. Again, the government's stated purpose in introducing those songs and the evidence is that they are admissions, not that the rap verses or videos themselves were conferred upon Mr. Wilson as quid pro quo for murder. The government fails to identify any evidence that supports the theory that rap lyrics and music videos are quid pro quo for the murder. At the November 18th hearing, the court directed the government to file those portions of discovery that encompass its theory as to bounty. So here, you're telling me that hundreds of pages filled that docket entry 293 encompasses, then what is it that the government would argue as to either bounty? On one hand, or the means by which allegedly Mr. Banks directed the crime occur. Docket number 317 at 30. And later, what I'm going to do is tell the government that if the government can rest on what it's already done, which is, as I was told, was in docket number 293. The government may supplement that between now and Friday. In response, the government informed the court that it rested on docket entry 293. That filing contains no evidence to support the government's current theory that Mr. Banks conferred features in rap songs or music videos to his alleged co-conspirators as a mutually understood payment for the murder. Simply put, y'all lying. Y'all shifted your argument. Hey, honey, yeah, you know about that thing you're talking about? Yeah, you were actually talking about this. No, the hell I wasn't. Yes, the hell you were. The government messed up by saying, yo, bro, hey, we had this meeting with Didi in some burger shop in LA where he allegedly paid people money, but we forgot all about that shit. And actually the text messages were supposed to do that shit. And then it actually wasn't. So now the text messages are trash. Now the theory that these cats sat in LA in a burger shop and passed along fat stacks of cash and all this shit, all that stuff basically just falls out the sky. And all of a sudden, we forget that Lil Durk lived in LA. That's why India was there like that. They're in LA, they're not in Georgia. Yeah, the government is right now, just in this argument, they getting BTA right now. They getting belt to ass because the government knows something that we all don't know. And that's the government's full theory. You just shifted your theory. And I said this shit months ago. Bruh, they're about to start depending on rap lyrics. How in the hell y'all go from he had money, he paid money, all of this crap to now, oh, I had them kill Lil Pop for a verse? And for them to hang out in a music video? But we're all OTF anyway, so it really wouldn't matter. Yeah, come on, man. Let's go. The government discloses a new theory. The government's January 16, 2026 404B notice, its third, marks the first time it articulates the theory that these rap lyrics and music videos are the items of pecuniary value exchanged as consideration for the murder. The notice again adds 2 new songs to the list in addition to those listed in the first 2 notices for a grand total of 12 songs. More importantly, it adds a theory as to an essential element of murder for hire that listed 12 songs or admissions and visuals showing the downstream benefits received by co-conspirators involved in a murder for hire scheme, including defendants and uncharged co-conspirators' participation in prominent placement in music videos following SR's murder. The government's January 30th filing on the 404B issue echoes the argument that the songs and videos contained in its third notice prove the downstream benefits rewarded to the co-conspirators involved in the murder scheme, including prominent placement in music videos following SR's murder. In its January 23rd filing, the government argues that the indictment coupled with the discovery provide clear notice to defendants of the government's murder for hire theory, docket number 349 at 4. It claims the government has alleged the straightforward theory that Mr. Banks rewarded co-conspirators by, among other things, featuring many of the direct participants in the murder in music videos and rap lyrics in the months following the murder. On the contrary, the government never alleged before mid-January that these or any music videos or rap lyrics were the consideration that Mr. Banks promised or paid in exchange for the murder, or that the expectation of these features were the motivation to commit the murder. The second superseding indictment merely names vague, lucrative music opportunities, which could mean many things from rap verses to concerts to record deals and beyond. In the wake of the second superseding indictment, the government has had every chance to make its theory clear. Instead, it is taking advantage of the indictment's vagueness, a carte blanche to continually disguise and reinvent its case at the November 18th hearing. Defense counsel articulated this danger and foreshadowed the current situation. Last night, we got a discovery production from the government, and I won't get into details because it's subject to a protective order, but it was an FBI 302, and it listed about 15 different music videos, and those videos involve or depict some permutation of Mr. Banks and Mr. Wilson, or Mr. Banks and protected witness one, some permutation of three of those people. And so I get this 302, and the first thing I think is, there's obviously these vague allegations in the indictment as a bounty. Mr. Banks provided lucrative music opportunities to co-conspirators, provided those lucrative music opportunities. But we are left to wonder, what lucrative music opportunities is the government alleging were related to bounty? So I'm looking at these music videos and I'm thinking, okay, is the government going to present these to the jury in such a way that the jury could draw an inference that Mr. Banks featuring Mr. William or PW1 in a music video is a payment of a bounty? And, one of the problems with a vague indictment is that it gives the prosecution free hand to fill in the facts and to fill in the gaps about which facts it wants to use to meet the elements. And it also illustrates the government's shifting theory, because we have a statement that there was never any music opportunity that was a bounty. And then maybe there was a fear of loss of a music opportunity that was a bounty. And now, are these new music videos going to be presented to the jury in such a way that they could draw the inference that those were a bounty? And so this is not just theoretical case law. This is something that prevents us from doing our jobs as the Constitution requires. This was an opportunity for the government to clear up any ambiguity about what its bounty allegations actually are. Instead, it chose obfuscation, which means they're lying. I love that word, by the way. The fact of the music videos that some of the defendants or protected witnesses are in together doesn't necessarily just have to be about bounty. It could be about motive. It could be about relationships between co-conspirators. It could be about the formation and organization of only the family. All of these points, as the government addressed in its opposition as to 404B evidence, are relevant. So music videos and presence within music videos is not just about a bounty. Either the government had not yet come up with the theory on November 18th that the music videos and rap lyrics were consideration for the murder, or it wanted to keep the defense in the dark about its quid pro quo theory in order to secure a tactical advantage, a concealment that would offend the constitutional principles of due process and notice. Y'all ever watched a TV show and y'all seen the audience laughing and they were just saying shit that we didn't understand, like when we used to watch Frasier and shit? That's one of those jokes right there. You're basically saying, y'all came up with this theory not too long ago, or y'all were hiding it, or y'all just hadn't gotten to it. Which one is it? It's like Hulk Hogan doing what you gonna do, brother? The hell are we doing here? So now, your original theory didn't work. Your second theory didn't work. Your third theory never included the music video. So now your fourth theory is they were going to get verses for killing Lil Pop. Instead of money to basically make them disappear so that they could never be seen again, I'd rather them frolic in music videos. And as they frolic in music videos, they're doing hand signs that basically do like this and go, no, and start rolling music videos and start acting like they driving, and like they would literally have to be in the background going, pull up, mask on, run up, shoot, then run back to the car, drive off, eat, sleep, get in the plane, fly, and now we back in Chicago, nigga. Come on, bruh. The new theory is a government invention and threatens to warp witnesses' testimonies. The government's newly articulated theory is its own invention, unsupported by the evidence. The government incorrectly asserts that its discovery clearly supports the straightforward theory that Mr. Banks rewarded co-conspirators by, among things, featuring many of the directed participants in the murder in the music videos and rap lyrics in the months following the murder. In actuality, the discovery contains nothing in support of that theory. This is why, in response to the court's order that the government file any discovery that would encompass its bounty theory and obviate the need for a bill of particulars, the government filed nothing that touched on this music features as quid pro quo allegations. No witness has ever told the government that Mr. Banks offered or rewarded features in songs or videos as payments for the murder. No witness has ever told the government the murder was motivated by the promise of a music video or rap feature. C. Chong affirming that its motive of the murderers, that it is relevant to whether the murder occurred in return for a promise to pay for something of pecuniary value. Not one witness, not ever in the place of actual evidence. The government appears to have searched the internet for every musical collaboration between Mr. Banks, the alleged co-conspirators, that postdates the charged shooting. It then constructed its own inference that these collaborations are the murder's quid pro quo. To reiterate, no witness to date has told the government that Mr. Banks paid for this murder with music videos and song features. The government lists in its third 404B notice, or with any music opportunities for that matter, or that the murder was motivated by the promise of expectation of such, and thus appears that these newfangled allegations are the inventions of the prosecutor's imaginations. The danger going forward is that the government's witnesses will change their stories to meet the requirements of the government's new theory. We have seen it happen already over the course of this investigation. For example, a witness who admits to the murder but denies that he did it for pay changes his tune in response to repetitive and suggestive government questioning about the payment. If it happens here, and if it happened at trial, any of the government's current cooperators testify that he was motivated to participate in the murder by the understanding that he would be featured in a music video or rap songs, then it will be downstream repercussion of this vague indictment, and it will be an unconstitutional miscarriage of justice. Conclusion: Mr. Banks continues to seek dismissal of this dangerously vague indictment. Short of that, however, he requests that the court require the government to file a bill of particulars that is tied to the theory it presented to the grand jury when the United States government seeks to charge somebody with the crime. It should be willing and able to inform him of what he has done that is alleged to have violated the law. The government should not be permitted to change its story along with the vicissitudes of the case, as it already has done here. First off, thank y'all for watching all of that. And if you want a chance to win one of these right here, make sure you subscribe. When we hit 300K, we're going to be giving it out to 2 lucky subscribers who comment on every video, like every video, and share every video. But I want to see what the government has up its sleeve. The government has to basically say something to the point of, oh, this is an ongoing active investigation and all this bullshit and everything, and this has to be this and this has to be that, because Drew and the team are right. Y'all never said this shit before. So why are you saying it now? What the hell makes today of muy importante? You know what I'm saying? What is it that you guys have found that basically makes all this shit happen? And does it compare and compete with what you said first? See, Drew is playing a dangerous game, because what he's saying is this: y'all never said this shit before. What they're probably going to say is, we did say this shit before. We had a music video up. Y'all didn't want that music video. Y'all said that music video was bullshit because it was recorded damn near 2 years before Lil Pop's murder. The government is now going to have to look at all of its snitches, witness, conspirators, co-conspirators, unindicted co-conspirators, cooperators, whatever the hell they call these cats nowadays, and go, you know what? Yeah, I'm going to get rid of your ass because you already changed your story up twice. See, what they're doing is they're testing the government's original theory to its new theory, with hopes that it cracks in front of the judge, so the judge goes, throw that shit out. Throw that shit out. Get rid of it. But y'all let me know y'all thoughts on this one. Do you think that Drew is full of shit? Like, bruh, man, nah, hell nah, bruh. Nah, that's nah, you know that it got something to do with music. Or you on my side, like, the government got thrown some bullshit. They didn't care. And they said, we're going to see if we can get him anyways. This is exactly what I believe happened. That certain people that was around Lil Durk's camp knew what the hell happened, held it in their back pocket, and decided if they ever got caught on some bullshit, that they were going to tie this whole entire thing up for the government, and that they could leech together everything and throw Lil Durk in there. Hell of a theory. This is why they need the Quando Rondo shooting to make sense. This is why they need the shooting, the other dude for killing his brother, allegedly, Stephon Mack, to go in. See, they're just piecing bullshit together. It wouldn't surprise me if the prosecution had like 15 officers, maybe even 30 officers from Chicago, 30 officers from Georgia that will try to corroborate their story, because that's all they have. Lil Durk is coming home. It's just a matter of whenever the trial starts. And hopefully the goddamn government doesn't make up a new theory and says, oh, Lil Durk actually promised everybody gold shoes. Anyways, y'all let me know y'all thoughts on this one. Or my bullshit. Maybe I'm just too Team Durk and I just can't see the hill before my eyes. Maybe I'm on bullshit too. Maybe I'm being paid for all of this. Who knows, right? Right. Why the hell am I living in this small ass apartment, man? God damn me. But anyways, click right here to see how NLE Chopper screwed himself over, but whatever. Or click right here for the playlist, and I'll catch you on the next one.